Many veterans are told that once VA labels a disability rating as permanent and total, that rating can never be reduced. That's not entirely accurate. Permanent and total, often called P&T, is a very strong protection. It usually means VA does not expect your condition to improve and does not plan future examinations, but usually does not mean always. There are limited situations where VA can still propose a reduction, and veterans should know what those triggers are. The first one is fraud. Under 38 CFR 3.105D, VA can sever or reduce benefits if it believes a rating was granted based on fraud or intentional misrepresentation. In plain English, if VA claims it relied on false statements or falsified evidence, it can reopen even a permanent and total award. These cases are rare, but they do happen. Second, clear and unmistakable error, often called CUE. VA is allowed to revise a final decision if it finds an undebatable legal or factual error, and that's under 38 CFR 3.105A. This is a very high standard. VA cannot reduce rating just because a different reviewer disagrees with the original decision. But if VA believes the law was applied incorrectly in a way that clearly changed the outcome, it may try. Third, evidence of sustained material improvement under the ordinary conditions of life. While permanent and total usually signals stability, VA may still act if it receives medical evidence showing actual long-term improvement. The improvement needs to be sustained and lasting, not just a good day or a single exam. Case law, such as Brown v. Brown, requires VA to show a real improvement in daily functioning, not improvement caused by rest, medication, or temporary circumstances. Fourth, administrative or jurisdictional issues. In rare situations, VA may argue that a rating was granted outside its legal authority or based on records later found to belong to the wrong veteran. These are uncommon, but legally distinct from medical improvement. Now, one final reminder. A proposal to reduce is not a final reduction. VA must first issue a proposed reduction and give you what are called due process rights under 38 CFR 3.105E. You generally have 60 days to submit evidence and 30 days to request a hearing. And I'm going to pause here and say, always request a hearing. If you do nothing, VA may finalize the reduction, but if you respond, you force VA to justify its position. So if you receive a proposal to reduce a permanent and total rating, do not assume it's correct and do not ignore it. These cases are often defensible, especially when VA overstates improvement or misapplies the law. That's all for today. Learn more about P&T ratings on the CCK Law blog or YouTube channel. Take care.